Good evening. I'm Mark Updegrove, the director of the LBJ Library, and on behalf of Dean Larry Sager of the University of Texas School of Law, I want to welcome you here tonight. In Justice Stephen Breyer's book, Making Our Democracy Work, A Judge's View, he writes, "At the end of the day, the public's confidence is what permits the Supreme Court to ensure a Constitution that is more than just words on paper." Anyone who knows Stephen Breyer's career and integrity as a judge knows that he inspires that kind of confidence, and we are honored to have him here this evening. Justice Breyer's history at the Supreme Court began when he served as a clerk for Justice Arthur Goldberg in 1964, when Lyndon Johnson was in the White House. He went there after graduating from Harvard Law School and then went on to become a lawyer for the Justice Department, an assistant Watergate special prosecutor, and the Senate Judiciary Committee's chief counsel. In 1980, Justice Breyer became a judge on the U.S. Court of Appeals for the First Circuit and was appointed the court's chief judge in 1990. 4 years later, in 1994, he was appointed by President Clinton to the United States Supreme Court. In making that appointment, President Clinton said, "Justice Breyer has a clear grasp of the law, a boundless respect for the constitutional and legal rights of the American people, a searching and restless intelligence, and a remarkable ability to explain complex subjects in understandable terms." I'm going to be counting on that tonight. Guiding us through our conversation with the Justice tonight will be Larry Sager, one of the world's most respected scholars in constitutional law. Dean Sager came to the University of Texas from the New York University School of Law, and prior to that, taught at Harvard Law School. He is also a prolific author on the subject of the law. Ladies and gentlemen, please join me in welcoming Justice Stephen Breyer and Dean Larry Sager.
Thank you very much. This is a wonderful book that we are about to talk about, and I can't resist giving it one specific plug before we begin. The title, as you know, is Making Our Democracy Work, A Judge's View. It's available in all the places books are available, and you will be doing yourself a great service if you buy at least one copy. So I think as this conversation will prove, it behooves you to do so. Justice Breyer, you end chapter 1 of this book, the chapter which in general speaks to judicial review, with a very funny and very moving colloquy from Shakespeare's Henry IV. And it goes something like this. Owen Glendower boasts, "I can call spirits from the vasty deep," to which Hotspur responds, "Why, so can I, or so can any other man, but will they come when you do call them?" Now, that's clearly meant to be an engaging theme for the entire book, and the spirits that are being called forth, as I understand it, are the American people and their support for the Constitution in general, and most specifically the Constitution as given meaning by the interpretations of the United States Supreme Court, however controversial or however divided. So my first question is, I suppose, a double question. One is, how optimistic or pessimistic are you about the spirits responding in 2011? And am I right in thinking that this book is intended to increase the likelihood of the spirits responding?
Yes. Also, by the way, if you'd like me to elaborate.
Yes, please do.
Thank you for your introduction. I think you might have waited until the end of the program to decide whether you wanted to recommend this book or not, but I'm glad you did. And the point of it is exactly what you say. Why did I write this? Really partly because Harry Blackman, who was my predecessor, told me when personal advice when I was first appointed really to his position. He told me two things. He said, first, he said, you know, you're going to find this an unusual assignment. That's true. And he said, people want to know about the court. They know that it's there. They know it has some effect on them some of the time, that it's important, but they don't know what we do. So this is really an effort to explain to people what we do, and it has to be interesting enough to hold their attention. And it has to explain why they ought to support, in an era where people are very skeptical about our institutions, very skeptical about government. And it has to explain why they might think about supporting this very unusual, undemocratic institution when what it does is often do things that are unpopular, and they may well be wrong, because we're people, not angels. So why would anyone support an institution like that? We don't like what they do, and they're wrong half the time. But why? And that's what I want to answer, and why is that question important? Well, Hamilton's really the one that gave this, and at the time the founders created this document here. This is the document. They wrote it, and they put in there, they didn't write these words, but they were thinking that it would be the Supreme Court who would decide when an act of the president or the administration or the executive branch or the legislative branch, a statute, was contrary to this document. Now why did he want us to do it? Well, I think if you read the Federalist 78, you will find that he hit on the Supreme Court for lack of anything better. That's the best he can do. He says, now suppose nobody has the power to set aside what the others do. Suppose nobody. Well, then let's put this up in the National Gallery on the wall so people could. He didn't say the National Gallery. I already used this joke earlier, but it's true. The National Gallery did not exist then, so he did not think the National Gallery. He did think a museum, perhaps. Well, hang it on the wall. Let them look at it. That isn't the point. Well, if it's meant to be put into practice, if nobody pays any attention to whether the branches are or not following it, you might as well hang it on the wall. It can't be put into practice. All right, who should have the decision-making power about whether somebody else is violating this Constitution? The president? Well, they thought the president was already too powerful. With this, he'll be able to do anything he wants. Nobody can hold the executive branch in check. So it can't be the executive branch. What about Congress? Well, that's not a bad idea. It is a democracy. But I mean, Congress, they're experts in popularity. A lot of this is meant to be helpful to people who are not popular. I mean, everyone, including the least popular person in the United States, has the same rights as the most popular. So give to Congress the power to say whether what they're doing when they've just passed a very popular law, which really tyrannizes some group that's unpopular, give them the power to say whether it's constitutional or not. That's expecting too much of them. They're too much, let us say, tied up in popularity. And if they weren't, by the way, they wouldn't hold the jobs they do. Well, who's left? This obscure group of sort of bureaucratic types called judges. Nobody's ever heard of them. They don't have the power of the purse nor of the sword, says Hamilton. Perfect. They have very little power. They know something about law, and this does have something to do with law. They'll probably try to do their jobs. Ideal, no one else. And they give, let us say, to the judges, that's what we'll say, or that's what we'll think, even though we didn't say it. But then he didn't ask the question that you just said, because after all, if we're giving to this obscure group, without much power, the authority to do things that are unpopular, and as I said, when they're human beings and not angels, they may also be wrong, well, why would anyone do what they say? That's put more eloquently by Shakespeare. I can summon fathoms from the, what did he say? See, I can't even say it. I mean, I can summon spirits from the vasty deep. Perfect. We need the support. But why will they give it? And that's the story I want to tell. And so I tell that through the use. It's a question he might have thought of, but he couldn't ask because he didn't know the answer. And that's a story that's taken us about 200 or more years to begin to answer.
Part of what you do in this book is you offer a view from your own vantage of how to do this, how exactly to summon these spirits. And there are two words that seem quite central to your description of a good judge's good work. One is pragmatism. The judge should be practical or pragmatic. And the other is that means that the judge should worry about how things actually work. And so the use of the word work in the title is far from incidental or accidental. So I thought I'd like to give you a chance to describe your thought process through this pragmatic lens with regard to a pair of cases that actually touch somewhat close, at least geographically, to this home, namely the two Ten Commandment cases. In two related decisions decided at the same time by the Supreme Court, up for consideration was the Ten Commandments monument on our Capitol grounds and the Ten Commandments script on the wall of a courthouse in Lexington, Kentucky. 4 of your colleagues would have held both of these displays to be unconstitutional as establishments of religion. 4 of them would have held both to be fully constitutional. And you alone sort of decided the case for the court because you held that in Kentucky, the Ten Commandments on the courthouse were unconstitutional, but the monument here in Austin was constitutional. That struck me as exactly the sort of thing a pragmatist might have been drawn to, and I wonder if you could describe how these two results seemed the correct ones to you.
I can. What I'm trying to decide, are we in a few minutes going back to the first area? Are you? About how is it that people have come to accept this document?
If you want,
you're quite right that what I'm trying to do in part of this book is to answer questions just like the one you've asked. Now, let's postpone where I wanted to go for a moment and go right to your question.
All right, but then we have to come back to
That's all I wanted, thank you. I'll show you something, because I am saying that part of the answer to the big question that I've asked, only a small part, the big part of answering how do we get support from our institutions is, of course, you teach people about the institution. And the people who are primarily responsible for that are teachers and families and lawyers and law students and everybody else in the world, along with judges. And judges have a small role. But part of the role is to try to get the court to work in a way that I think is helpful to most people, and that's where you are. So what I say, if I want to use bumper stickers, and I like bumper stickers because bumper stickers are useful. They give you an idea of where the person with the bumper sticker is going. So when I talk about a bumper sticker, I will say that the general approach in the constitutional area that I think works pretty well is indeed to look back, because as you know, there's division of opinion in the court about how much we should look to history and how much we should look to other things. And I more tend to look to other things, but I don't ignore history. And I say it's important to look at history of this document and to look at, here you're talking about the Establishment Clause. The Establishment Clause says that Congress let me get it exactly. Congress shall make no law respecting an establishment of religion. Interestingly enough, that's the first words of the First Amendment to the Constitution. But what I say I do as a bumper sticker is let's go back and look and see what the framers were aiming at. What's the basic value that underlies those words? What's their basic principle that they're trying to write into those words? For example, with the Commerce Clause, it's giving Congress the power to regulate interstate commerce. With the First Amendment, that doesn't mean that George Washington knew that I would be able to fly to Texas in just a few hours. Well, the First Amendment protects the establishment of religion. No, sorry, free speech, free expression. That doesn't mean George Washington knew about the internet. But I'd say the job is to work out the values which are pretty permanent, which George Washington did know about, and then see how they apply to a world of the internet where circumstances change. I have to give that long introduction in order to tie in an answer to your question, which is a good one. What underlies these words, the Establishment Clause? Well, people argue about that. And they argue about how much detail you want. As far as the framers are concerned, they thought it applied only to the federal government. They didn't think it applied to the state. But the 14th Amendment came along and applied a lot of the First Amendment, and the Second Amendment, the Third Amendment. A lot of these amendments applied to the states. By the way, I shouldn't have said second because I thought I dissented in the gun case, but nonetheless. But you see, get the point. You get the point. And the fact is, what is this Establishment Clause about? One of the better things I read on that was an essay that Archie Cox, who I worked for at one point of my career, he told me about this essay at some lectures given at Northwestern University by Lord Radcliffe, who was a great British judge. It's called The Law and Its Compass, and I would recommend it. And he said, interestingly enough, most of our modern liberties, including free expression, including freedom of religion, including lots of other freedoms, come from the period of the English Civil Wars. And of course, as we know, that time, the 17th century, was terrible in Europe. It was just terrible. I mean, they were murdering each other and killing each other nonstop in the name of religion. And finally, says Lord Radcliffe, after they burned enough people on both sides, they decided to call a halt. And they said the very basic principle of the truce is going to be, you follow your religion, I'll follow mine. You teach your religion to your children, I'll teach mine to my children. And out of that basic compromise grew a lot of other liberties. But if you see that basic compromise as terribly important, and if you see it as growing out of the English Civil Wars, you think then that very important to the Establishment Clause is the notion of, in this way, by keeping government out of religion, we will tend to minimize conflict among religions, and including those who have none. But we don't want religion to be a source of conflict. Well, once you think that, then when I looked at this case, and you're right, it was 4-4, and I was right in the middle, and anyone who thinks that's nice is not having the experience I'm having. But I said to some of my fellow judges when I was having a hard time figuring out which way to go, well, one nice thing about being in the middle here is you get a lot of company because they keep visiting you, the other judges. so ultimately, I thought this. I thought, well, we have two cases, and one is a case, I think was Kentucky, wasn't it? And what they had done is they'd hammered, somebody up there had hammered the Ten Commandments up on the wall, and it was pretty clear what he was after. He was trying to say the court's all wrong, and it was going to be, and I want to do this purposely to show I can do it under the law, and other people said he couldn't, and I thought that was a pretty good source of conflict. And this was using those Ten Commandments deliberately as a religiously inspired document in a way that would create conflict. All right, I contrasted that with Texas. It's true that on the state capitol there is a monument to the Ten Commandments. Do you know where that came from? You may know because you read this. I bet they don't, most people don't know. Cecil B. DeMille made a movie called The Ten Commandments, and in order to inspire customers, he gave money to a group called the Eagles, which was a civil group, to put Ten Commandments monuments all over the country so that people would come to the movies. I didn't think that was, and that had been there for quite a long time, and it was with other monuments dedicated to the principles of Texans. And there are plenty out there. Now, you know this better than I, because I haven't really inspected the monuments firsthand, and probably some of the people here have. And they're all their monuments to the women of Texas, to the men of Texas, to, I mean, the pioneers who came to Texas, all kinds. And this is just but one monument to the ideals of the Texans, along with a lot of others, and it never stirred up trouble. So it really went through my mind, which I wrote, you know, if you're going to have a principle of law that requires everybody to sort of get up there with chisels and chisel up every reference to the Ten Commandments in every public building in the country, you're going to have a lot of trouble going. And if you also inspire people to put up religious documents as a source of showing perhaps a religiously inspired conflict, you're going to have a lot of trouble too. Now, I actually wrote this in a more articulate way than I'm saying it right now. But I think those are the basic ideas why I thought one was against, contrary to, wrong, and really fell within the scope of what that establishment cause was trying to prevent, because it was very religiously inspired troublemaking, and the other went the other way for exactly the same reason. So I didn't think I was being inconsistent. What I was trying to do, for better or for worse, was to take a single principle related back to the history of the Establishment Clause, related to its basic purpose as it has come to be seen today, and then applying that purpose, those words, in light of that purpose, to two factually different situations. And since I thought those situations were factually different in a significant way, I came out differently.
I promised you a chance to circle back to the spirits in the vasty deep. So these decisions come down, and you write handsomely and articulately the defense that you just gave. And in your book, you, by example, write a defense of what judges in general do in our constitutional order. And there are wonderful gatherings like this for you to speak to all this. Are there other ways that the court can reach out and do best to ensure that the spirits will come forth and that it will enjoy support?
We can't do much about that, because I'm sure going through people's minds as I say this is, why should I have the power to make that decision? We live in a democracy. And I'm sure as I articulate it, people are thinking, oh, that's sort of interesting, it's a little abstract, and maybe it's wrong. And I have to sit there thinking, maybe it is wrong. And I'm simply doing my best with a very difficult problem. And so then we come back to what I'd call the basic idea. Why 9 people? And I think there is no better answer. There is no better answer than Hamilton's answer. Because we have to find someone to do this, and because it's too risky to give the power to Congress because of the need to make unpopular decisions. And I'm sure my decision in that case, and in a lot of other cases, was very unpopular with many people. And so what you have to say to these people is what? Well, I tell them some stories. And the stories, I'll tell you what they are, because I'm obviously trying to get him to ask me so I can tell you.
I will. Let me see if you tell some wonderful stories about Marbury, the Cherokee cases, Dred Scott, Bush v. Gore. Not all decisions that necessarily covered the court with glory. And I'm happy to invite you to address them, but I have a question that may take you into another set of stories first. And that is, in the book, at one point, you say something quite arresting. You say, if a genie gave me 3 wishes to make 3 of my dissents the majority for the court, one of them would be the Veith case. And the Veith case also, which touches close to home in its own way, is the case in which 5 justices of the court on slightly different grounds declined to intervene in politically motivated gerrymandering. And you were one of the dissenters who said there was a threshold of political motivation which made redistricting unconstitutional, and that the court ought to be able to apply a test to ferret that out. My obvious question is, what are the other 2 wishes?
Well, gerrymandering, I thought there were extreme cases of gerrymandering where the court could say that this is not giving people a fair chance to vote. And that was debatable. And obviously the reason I put that first is because I suspect from reading papers and talking to people and so forth, and certainly that gerrymandering is a problem. It is a problem, you just have to pick up a paper and read. So that's why I thought that's why I listed that. The other two, I didn't have anything particular in mind. I just thought it sounds better if you say this is.
I don't know whether to believe you about that or not.
Well, it varies. Say the content of the other two vary the decision that I was at the time, and I still am rather unhappy about, was a decision where I thought there's a very, very important and interesting and difficult question about whether the Constitution, in the 14th Amendment, which says a state cannot deny any person of equal protection of the law. Well, it's quite clear that was meant, certainly after Brown, to prevent invidious discrimination. That everyone agrees with. But what about positive discrimination? What about affirmative action? Can you use race ever as a criterion for admission to a school? I know this is an issue here. And my view of that was, yes, you can sometimes, if you're careful about it. And I thought that was consistent with the clause. But again, you'll see the same idea. I mean, there are those who think that the only way to interpret that 14th Amendment is to make it colorblind. And there are strong arguments in their favor. And if it's colorblind, you cannot use race as a criterion to achieve diversity or invidiously to discriminate. But there is a different view of that phrase. You say, let's look in part anyway to what its objective was. It's written into the Constitution after the Civil War. It's written there in order to bring people who had been slaves into full membership of the American political community. And if you look at it in terms of its purpose, you could say, and I would say, that something that tries to be inclusive in its objective, although it still could violate the amendment, but it's different from something that tries to be exclusive and further invidious discrimination. So I wrote that there is a difference between positive, it's not always lawful, but there's a difference in terms of the purpose of the amendment between what is positive discrimination in order to achieve diversity and negative. All right, now that's consistent with, I'd say, a view that looks back to see what the objective of these amendments are, what their objectives, and then tries to apply it in light of those objectives to results today. So 5 members of the court held, and I was one of them in a case called Grutter, that you could use race, if you did it carefully, in order to achieve diversity in a law school. In another case called Seattle, 5 members of the court thought you could not use that in order, they were trying to stop white flight, basically, in Seattle and Louisville in secondary schools. And I dissented. I felt pretty strongly about it. So my way of punishing my colleagues is to write a very long dissent, then they have to read it. And I spoke at some length from the bench. And there we are. So you say, would I like that to have come out differently? Obviously, I could go back and look at my strong dissent, you know, where I felt pretty strongly in dissent. But I put Veith first. And there we are. I mean, that is a way we decide. We vote. And we write our reasons. And we try to convince the others. And sometimes we're successful. And sometimes we're not. And that's true of every one of the 9 of us. We all understand that. People do have different views about things, and we try to reason our way to a conclusion. And that, I think, is a way that's best aimed at assuring people that there aren't just 9 people out there doing whatever they happen to think is a good thing. There is something called law, and there are approaches to law, and there is a reasoned opinion that has to be written. and has to tie the judge's hands to a document that he or she will write and that ordinary people can understand and criticize. That's what it's about. And that's one way of holding the judge's discretion in check. And it's one partial answer to those who are worried about the Hamiltonian decision to turn this kind of power over to 9 unelected judges.
One last pass at the stories, which you tell. You describe a number of cases vividly and movingly, but 2 of them really are bookends and seem quite extreme with regard to the spirits from the deep. One is the Cherokee cases, and the other is the set of events that culminated in the showdown in Little Rock, Arkansas. And I wondered if you'd like to talk about those 2 situations.
Well, I put those in because the first is, they mean something to me. I mean, I've gone, when I read a decision, even if it was written, even if it's Marbury versus Madison, I'm a judge. And I'm a judge on the Supreme Court. And so there's an element to this where I'm looking back and reading a decision, I think, well, that's a person who held a job like mine. And he had to make the same kind of decisions that I'm making. And I'm interested in it from that point of view, even if times are different, even if things do change. Not everything changes. And I'm reading it from that point of view. And remember, Hamilton is thinking, perhaps, but he doesn't ask the question, why will people do what these 9 people say, or 7, or whatever there were then? Why will they do what the Supreme Court says? Why? And sure enough, a case comes along, and I'd like people to know about it, the Cherokee case. And in that case, basically what happened was Georgia decided to take northern land in northern Georgia that treaties had given to the Cherokee Indians. Absolutely clear that these treaties said this land belongs to the Cherokees, signed by the United States of America, and they found gold there, you see, and so the Georgians thought, why should the Indians have it? We should, so let's take it. That's an idea. But the Cherokee tribe at that point, they had a constitution, they had schools, they were farmers, and they did what any civilized group of people would do. They hired a lawyer. Now, the lawyer was a great, great lawyer, Willard Wirt. He was one of the greatest lawyers of his day, and he had a hard time getting this case to the court, but eventually he did. And the court said pretty much what I've just said. Well, this land belongs to the Cherokees. And President Jackson, and this is why you may have heard of the case, President Jackson supposedly said, and he said something like it, well, John Marshall made his decision, now let him enforce it. And he sent troops. He sent troops to Georgia, but not to enforce the decision, to evict the Indians. And the Cherokees followed the Trail of Tears, so-called because so many died, along the way to Oklahoma, where their descendants live. So I'd like that to be a picture in people's minds. And then I roll the clock forward, and I want another case to be in people's minds, too, because it made such a difference to me, and I'm old enough that I can remember it. This was in 1957, and this was in Little Rock. And the court had decided Brown versus Board. The court had said that there will not be segregated schools anymore, and the implication was there won't be segregated anything, not legally. And that's it. And so they decided that in 1954, and probably some of you will remember and others will know what happened in 1955. The answer basically is nothing. Nothing. It's like the Cherokees. 1956, nothing. Next to nothing. 1957, a judge in Little Rock with a moderate school board said there will be integration in Little Rock, and they're called the Little Rock Nine. 9 very brave students, black, are going to be integrated and go into that white school. Yeah. And Governor Faubus, whom some of us remember, said, in effect, that's fine, but I control the local police. And he sent the state militia He sent the state militia really not to promote the integration, but to prevent it. And the White Citizens Council surrounded the school, and there was chaos for the couple of days in September. And eventually, President Eisenhower, it was Brooks Hayes, who was the congressman from Little Rock, and he arranged a meeting with President Eisenhower at the summer White House in Newport and Governor Faubus. Governor Faubus went up there, he met with the president, he came out, he said it was like a general dressing down a lieutenant. But he told the president he'd go ahead and support integration, and then he came out and told the press the opposite. And Eisenhower was not happy about that. But he was getting advice. He got advice from Jimmy Burns. And Jimmy Burns, as some of you also know, had been a member of the Supreme Court. He resigned during World War II in order to run Roosevelt's mobilization effort at home. And then he was a great advisor to President Truman. And he wasn't a terrible racist. And he told President Eisenhower, if you send troops to Little Rock, you will have to occupy the entire South. He said, you will have to have a second Reconstruction. Are you prepared for that? He said, the very best thing that'll happen, the very best thing is that they'll close the schools and nobody will get educated. At the same time, Herbert Brownell told Eisenhower, you've got to do it. It's a question of the rule of law. It's a question of enforcing this decision. You've got to do it. And Eisenhower decided to do it. And he rejected Burns' advice. And he decided deliberately, he knew what he was doing. It was the 101st Airborne. And I can remember, they were heroes in World War II. It was the 101st Airborne that had gone into Normandy, and their parachutes sometimes had gotten hung up on the steeples there, and there were pictures about them being shot down, and they were heroes of the Battle of the Bulge, and every American in 1957 knew who the 101st Airborne was, and Eisenhower put 1,000 of those troops into an airplane, into several, and they flew to Little Rock, and the next day they walked with those children, those black children, into that white school. Now that was a great day, I thought, and most think, and everyone really does now. That was a great day for the law. It was a great day for the courts. It was a great day for America. That cause of integration and equality. I just wish I could end the story there. See, but you can't. You can't. Because they stayed there for a while, and then a new school board was elected, and then they closed the schools after they went to the Supreme Court. Oh, by the way, in the Supreme Court, all 9 judges signed a document called Cooper versus Aaron, where all 9 said, you really have to integrate. This is exactly right. You have to do it. They're completely right. Go right ahead. And you could have had 9 signatures, which is rare on a Supreme Court opinion. That's an unusual thing. It was meant to indicate all 9 want this to happen. They're judges. You could have had 900, 9,000. So, and the next day, Governor Faubus closed the school. Yeah. And the children went for a year without education. Not quite a year, but till the end of the year. But to me, anyway, the die was cast. The die was cast. They couldn't keep it up. And a lot of other things happened. There was Martin Luther King. There was the civil rights marches. I was just looking at one of the photos up there, and I saw that day when Lyndon Johnson gathered all those civil rights leaders here, and he spoke to them. I mean, there are lots of fabulous markers on this journey, but one of those markers, and for me as a judge, one of those markers that has always moved me emotionally, and I thought helped a lot in establishing that we would follow a rule of law in America, was the decision to put those 1,000 paratroopers into those airplanes and to bring them to Little Rock to enforce that law. Great, wonderful thing. I told that story to a Russian general who had been sent to the court, and he had been the man who was supposed to, he'd been targeting the missiles. And we got a call from the State Department, And those missiles, they said, this man has changed the direction. They're not pointed at the United States anymore. We should be nice to him. Please take him around the court. So I thought that was a good idea. So he asked me, well, what are your favorite decisions? You know, what's your favorite? So I said Brown, of course, was a great decision. But I said, my favorite, Cooper versus Aaron. And I told him the story. And I said, the moral of the story? Paratroopers and the judges must be friends. That's it. Now, I'll tell you, I mean, think about that one. And I think that made a difference. Of course, we'd had a lot of other things that happened in the history of the United States. So then I want to go on to Bush versus Gore. Because the most interesting thing to me...
I was assuming that was going to be one of your three wish list cases.
Yeah. Why? I was in dissent in Bush versus Gore. And I think that was a case probably pretty unpopular, at least in a lot of quarters. And I think it was wrong. But the most interesting remark I heard about it was made by Harry Reid, the president of the Senate. And he said the most remarkable thing about that case is rarely remarked. And that is that despite the fact that it was unpopular, and in the view of many, and I imagine he's one of the many, totally wrong. There were no guns. There was no physical rioting in the street. People did not throw stones. It was accepted. And he said that was a treasure. I know in any audience, particularly if it's a younger audience, I think if people are thinking, well, too bad there weren't, too bad there weren't. And a lot of people think that, and I say to them, as I'm sure that Senator Reid thought, before you decide that it would have been a nice idea to have guns or stones or people being injured, turn on the television and look and see what happens in countries that make their major decisions that way. You see, that's what I want to show. I want to show we've at least come to a point where 307 million people who are all, believe me, I mean, we know every race, every religion, I say every point of view. I mean, my mother used to say that. I repeat that always. My wife says if I tell this joke one more time, she's walking out, but she's not here this evening, so I can tell you. But my mother, who was from San Francisco, she used to say, there is no view so crazy. There isn't somebody who doesn't hold it. They all live in Los Angeles. Anyway, you understand the point, and believe me, it is diverse. It is diverse. And yet, this holds them together, a rule of law, this document, the Constitution. And so what I want people to get out of this really is the complexity of it. You can't really point to one decision. You can't say, oh, well, this is it. Oh, it's all sure for all time. You see the difficulty in what does it mean to follow a decision, and when are you doing it, when aren't you doing it, and why is it accepted? I get questions all the time from judges who are from Asia or from Africa or Latin America, and they say, what is the secret? And I just had a woman who is the Chief Justice of Ghana. About 2 years ago, she's in my office, and they're trying to bring to Ghana a real democracy and protection of human rights, and she is the Chief Justice of the Supreme Court, and her work is cut out for her, and she's trying to do it. And she says, well, what's the secret? And I want to say, well, it is a very good document. It's short, and it's clear, and it's really well written, and but it isn't that just. And I want her to hear the stories. I say, if you have 10 or 15 minutes, I want to tell you, because it's a question of getting on people to understand, people who aren't judges, who aren't lawyers, who are Americans who are busy and have a lot to do. They have lives to get on with. They have to make a living. They have families they have to raise. It's hard. But to understand enough about it that they will see why this is a treasure, the fact that we will in fact allow 9 unelected people called judges to try to protect those who might be unpopular, and even though they might sometimes be wrong. So that's really the main point, and this is not necessarily something we on the Supreme Court can affect very much. It's really up to teachers and families and those who are in a community to talk to each other. And I said to lawyers, go on law day to talk to the students, go talk to the high schools, or bring them into the courts and show them what you do, and explain to the editorial boards what it is you do in law, so that they begin to understand this. So I'm great for that, and that's why I say I just think this is it's doing what anyone can do. You see, you do your bit. And I can't guarantee that judges deciding one way or another, or even the way I think they should be decided, will bring about some kind of nirvana. It certainly won't. But that's the object here.
Thank you. I'd like to turn now to a topic that is really not taken up actively in your book, but is just below the surface. You talk a lot about divided votes. You talk about the 9 justices. You talk about the cases in which you have found yourself a dissenter. I wonder if you could say a little bit about the formal and informal relationships among the justices of the court. To what degree intellectual companionships take place, to what degree persuasion takes place, to what degree you would be or not be tempted to shade the articulation of a position, to gather more support and so forth. This is a very complicated 9-person body, and I think it'd be very interesting to hear what it's like to be a member of such a group, doing the already complicated job of deliberation you described.
It is complicated. The easiest part is the personal relationships. The personal relationships are good, and they always have been good. I've been there, or at least since I've been on the court, for 16 years. I've never heard a word. I've never heard a voice in that conference room. We're alone in the conference room when we discuss this, and I've never heard a voice raised in anger. And I've never really heard one judge sort of insult another, not even as a kind of joke. I mean, it's professional. And I want the law students to understand that. My goodness, I mean, sure, somebody says something that I really disagree with. How would it help to be angry? All it would discredit. When somebody's angry and they're arguing with you, it just discredits him. You think, well, he's probably wrong. It wouldn't do any good, and we're not. It's professional. We set forth our views. We say how we're seeing the case, and then there's some discussion back and forth. Sometimes a little, sometimes a lot. But it's very surprising how much you can say very succinctly in a very short period of time when what you're doing is trying to explain how you see this case. And then a little discussion. But the discussion is not of the nature, I have a better argument than you. It's just going to lead you to say, I have a better argument than you. What good is that going to do? The kind of discussion that's useful is if I'm listening to what you're saying and then thinking from your perspective, have you considered this? And that sometimes is helpful. But I mean, it's 9 individuals, and there's no, they're not pushovers. I mean, they think through these cases, each of these 9 people, and each of us understands that each of us, I have to work out my view of this case. And in that sense, it's very individual. And we also understand that you cannot have a court, and we won't be doing our job unless we get 5 people at least on an opinion. And we are therefore prepared to go along with what other people say up to a point. And what is that point? I can't articulate it. I don't know. About 40% of our decisions are unanimous. The 5-4s you always read about are about 20 to 25%, not always the same 5 and the same 4 either. And, but they're often the high visibility cases. And how do we get everybody together? 5. You know, before I was appointed, and I was a law teacher, I used to say, I know why they have this 2 on here and 3 on there. It's just ego. They just want, like the Constitution, according to Justice so-and-so. But there's just one Constitution. People feel that they want a result. They want it to be clear. They don't want 5 different opinions. So lo and behold, I'm there 2 years, and we get a case called Turner Broadcasting. In Turner Broadcasting, there is a rule of the FCC, or maybe it was Congress, I can't remember, and it said a cable operator must carry an over-the-air station to give to the cable operator's viewers, and then the cable operator said that violates the First Amendment, because we don't want to have that on. That's content that we don't want to carry, for whatever reason. Is it monetary reasons? They say, well, perhaps we're not, but we don't want to and we don't have to. First Amendment protects us. All right, so we had 4 people who said Congress can require them to take that because there's a good reason for it. It has to do with antitrust law. And 4 people say Congress can't make them do that because the antitrust reasoning of the first is just wrong. Now, I'm an old antitrust law professor, and I think these last group is right. It is wrong, absolutely wrong, but I think Congress can make them carry that anyway. So what do? I write one of these opinions which says the majority is right for reasons proposed by the dissenters. I mean, you know, it doesn't. All right. So now I'm trying to illustrate for you something. I couldn't, my God, I spent a long time in the antitrust law, and I just can't sign on to those to the reasoning of the majority. I think it's wrong, and yet I do think their result is right. So I sit down and write my opinion. You say, well, was that? It was. I just couldn't do it. I couldn't bring myself to do it. And so I use that as an example and try to show you that it's highly individualized, but people want to try to compromise. They want to. And then there's something, it's not every word. I certainly don't, nobody requires every word to be something he agrees with. Everybody understands the need to reach a single result. And yet sometimes you just can't sign on to that. And that line will be different for different people. But that's what's going on.
Thank you. And I have a question to take us, well, actually, I see Mark here in the doorway, which I think means that he has a raft of questions that he wants to propose on the audience behalf. So I think I'll stop here and thank you very much for this conversation. And turn you over to the mercies of the audience.
Thank you, thank you.
Larry, thank you very much. Justice Breyer, I have several questions from the audience written out here. The first, you talked earlier about what goes on behind the scenes when you're talking to your colleagues at the court. But I wonder, one of our audience members asked, do oral arguments that you hear at the court ever sway your opinion on the matter?
Yes, absolutely. The law clerks all think not. Because they see a lot of cases where you're sort of tending to go this way, but they do sometimes. I would be surprised. There are 2 different things that happen. One is, like most decision makers, when most people have to make a decision that doesn't concern themselves anyway directly, what you tend to do is you hear the issue and you already have an opinion. When I open that blue brief, the petitioner's brief, I read the question, I already have an opinion. Then I read the red brief, the opposite side of it. Oh my goodness, I guess I was wrong. Then I read, so an open mind doesn't mean you start with no opinion. It means being open to persuasion. And it's much more like that old joke, you know, the lawyer says, here's the plaintiff's side, and he says, you're right, you're absolutely right. And the defendant says, you haven't heard me. So the defendant argues, says, you're right, you're absolutely right. And the plaintiff's lawyer gets up and says, my God, you just said I was absolutely right. Now you're saying he's absolutely right. We can't both be absolutely right. And the judge says, you're right, you're absolutely right. But that has a grain of truth in it. And so what's happening is I've read the briefs, I've talked to my clerks. My clerks have written a memo, we've discussed it, and then they've read the brief. So we've had them reading the briefs. I've divided them. They're supposed to really know it, and I've read the briefs, and then we have the memo, and we discuss it, and then I'm ready to go into oral argument. Well, it's becoming narrower and narrower, and the possibility of my changing my mind is getting less and less, but it's there. And it's really with the oral argument that it becomes more firm. So if you say, how often does the oral argument shape the way I look at the case, shape how I think would write something about this, shape how I think it sort of falls out, what these issues are like, the answer to that would be a lot. How often does it actually change me from A to B, exact opposite? I bet if it's something like, I think 5 to 10% it's not, I'd say it's not much less than that. And if you start going around 15%, it's probably not more than that. So that's just a guess. But I do go in thinking sometimes it's this, and then I listen, and I'm shaping my own view there, and yeah, I'll switch sometimes. Not a lot, but it will. It's very important. The lawyers know that too. The oral argument's pretty important.
The next question is there a constitutional limit on free speech? And the context they give is particularly as it relates to that preacher down in Florida who wanted to burn the Koran.
So I'm not giving an answer to that preacher in Florida. I'll tell you that. Is that and the answer, are there limits? Of course there are limits. All human conduct is conducted through speech, or almost all of it. And aren't there laws against, for example, robbing banks, even though you issue all the instructions in writing? And even if you only never even get into the bank, you just get to the door. In fact, you do nothing but talk. Of course, there's criminal laws all over the place that prevent certain kinds of speech, fraudulent speech, etc. There are laws that, I mean, there are lots and lots of things. In the security area, there's a famous thing by Holmes who said, you can't yell fire in a crowded theater. And then there are cases that say you can burn the flag as a symbol. And then there are cases that say, and try to deal with this terribly difficult question of national security and the Pentagon Papers case. And there are dozens and dozens of cases that go into that question of what the limits are. And all I can assure the author of that question is it's an excellent question, and there is not a clear, the answer is yes, there are limits, and if you're hoping for a clear answer as to what those limits are, you're not going to get one.
And that's your right to free speech, right there.
No, it's my right to silence.
Right. We had several audience members ask you to explain Connick versus Thompson.
Well, you have to tell me what the issue is, because I remember by issue rather than by name. You're talking about?
I have a short question here, and that's the extent of it, so we can move on to another question.
The law professor is totally different. He has to remember everything
Yes,
by
but
name.
I don't want to embarrass you by talking about it.
All right, there we are. Next time, put it down by issue or on to the next question. I'll remember it in the middle of the night, you know.
This is an easy one. What advice would you give to aspiring law students about the judicial system?
I'd say you're part of it. The advice I give is it's an amazing thing, as I said, that 307 million people have agreed to follow rules of law. And I'd say that you're part of that system. Amazing in America how much of the law grows out from below. It bubbles up. It's not the judges who lay down the law or even the Congress. We have a very complicated system where lawyers, those who aren't lawyers, academics, everybody discuss things. That's what Tuckville said. He said the first thing that struck him on coming to the United States, he called it the clamor. He said it's the clamor of everybody arguing. But there's something healthy about that, and we argue in law reviews, we argue in the newspapers, we discuss things in meetings, we belong to different groups. When we have a big problem, say, think of the problem of privacy and the internet and free speech, and everything's changing in respect to that because of the introduction of technology, and how are our old rules going to change to deal with these new technological things, Facebook, Twitter, internet, etc. And I wish I knew the answer to that, but I know where the answer will come from. It will come from a lot of discussion, debate, administrative rules. Maybe they don't work out, maybe we change them. Maybe there are hearings, and maybe it's the state legislature, or maybe it's the local city council, or maybe it's in Congress, and they might try something. And I know our court system works best when it comes in last, because all we're deciding is not the wisdom of policy. We're trying to decide whether the guidelines, the boundaries that are set by this document are exceeded. That's quite a different matter. This sets down some boundaries. And then we have to say, did you go over the boundary? Now, life on these frontiers here is not always easy. It's not always easy to say whether abortion is inside the boundary or outside. It's not always easy to say whether prayer in schools is inside rather than outside. But between these boundaries, there is a vast area where people in our country decide things in very complicated discussions and ways, and it's basically a democratic system. And that's why what law students will have to do is wonderful. They're part of the system, and they will participate as part and try to explain it to others. And it's great to be a lawyer, I think. I know it's not a popular thing necessarily. But you've decided, if you're a law student, to go into a profession that requires both a heart and a head. Now, that head is treasured because law is complicated, and you have to understand it. And you have to be able to help other people, and that's where a heart comes in. So it combines those two things. And for that reason, when it's working at its best, it's a privilege to be a member of that profession. And that's what you are as a law student and will be. So I hope you decide 10 years from now that you've had a private career, maybe partly a public career, and you've participated in the life of your community. And I hope you're proud of, will be proud of what you've done. So welcome to the law. Thank you for deciding it.
Our last question is my own, Mr. Justice. We have several members of our audience who were clerks at the Supreme Court. Several were your clerks.
Yes, I saw that.
And I'm sure we have a number of others who are aspiring clerks for the Supreme Court. You, of course, were a clerk back in 1964, and 30 years later, exactly, you became a member of that court. What was your greatest surprise upon becoming a member of the Supreme Court versus how you viewed it as a clerk?
Well, one of the surprises was I discovered being a justice is a lot more work than I had thought. And I'd say the great difference then, I clerked in 1964-65. Well, that was a court that had a mission, really. I mean, in 54, they had decided Brown. And the question really was, over and over, what can we do about the South, the legal structure upon which segregation rested it was pervasive and enormously complex. And the court was continuously and very often involved in trying to make that promise of Brown become meaningful. And it had spillovers in other areas. And that is not true today. That is not what the problems are. Life changes. And it is not necessary. It's a different court. And problems change and the world changes. And so it is not the court that I clerked for. And I have to deal with a different set of problems by and large. And maybe that surprised me a little because of my past experience. But that was a reality which I understand.
Well, I have several thank yous by way of concluding. Number one, Justice Breyer and I were standing backstage, and I told him that we would fill this hall tonight, and he said, no, you won't, certainly you won't fill it. And I'm delighted that we did, in fact, fill it. And I want to thank you all for coming out and doing that. And I would invite you to come back to help us fill it in the future. Dean Seger, I want to thank you for a very lively discussion that you moderated. And Justice Breyer, I want to thank you not only for the judge's view that you provided tonight, but for all you do to make our democracy work. Thank you so much.
Thank you.